taken a different level of, has actually taken a different level. Force majeure was something that pre-COVID, I mean, most of us lawyers perhaps would not even have thought about, or, the existence of a clause like this in many of our contracts. And then COVID hit us one day. And as they say, कि वक्त बदलने में time नहीं लगता. So I think that's how exactly what happened to force majeure. Moment COVID happened, I think since then all of us lawyers will sote jaagte, force majeure, force majeure, force majeure. I mean, that's exactly how it was happening. Seldom people, hardly people knew what clauses do they have in the contract. Hardly people knew what is there in store for us during COVID. But bas, force majeure clause hai ki nahi hai? I mean, that was all that was giving us sleep or sleepless nights during COVID. So those were the times of COVID, I think, which were very, very interesting. And to further the understanding and to, take what we all went through during that times, we have our fantastic panel. I think it's a right mix of panelists that we have. Chanchal is the external counsel, litigator, who advises a lot of banks and BFSIs on, on various issues, and I'm sure he would have dealt with many such aspects during COVID, and maybe some litigations may still be on, so, considering the judicial system in the country we have, with no pun intended. And of course we have Navin, who would have his say from a public sector side of things, and then Amit from a microfinance or MSME perspective. However, just to set the context, I'm sure we all now know what force majeure is, what force majeure means. I really don't think, I need to really tell you what force majeure is all about. However, the way we have still seen the struggles that we had, especially during COVID, was crazy. We really didn't know what to do. Even if we had a force majeure clause, I'm sure most of our agreements since then did not have epidemic or pandemic as one of the specific inclusions in our contracts. Some contracts said act of God, some contracts didn't say act of God, some contracts were very inclusive, some contracts were extremely exclusive. Hardly any contracts, at least I have seen, who really had a catch-all clause. We had different kinds of contracts, different kinds of clauses in the contracts. To add to it, when COVID hit us, all we were busy in were sending notices to each other. I mean, the counterparty has sent you a notice of force majeure, but you're not satisfied. You also want to send a notice back to them. What for, I don't know. But that is exactly what we all did, right? At least I did, or most of us did. And that's how our journey on force majeure evolved. Of course, some departments, some ministries were little proactive, like Ministry of Finance came out with a notification as early as in Feb or March 2020 itself. While it was seeing disruption in the supply chain, considering lockdown in China happened much before lockdown was even heard in most of the other parts of the country, of the world. Finance Ministry of India came out with a notification being proactive, saying that, any disruption in supply chain because of lockdown or COVID or lockdown in China would be sort of construed as an event beyond the reasonable control of the parties, and thus there should not be any action against the parties who are not able to perform due to that. Taking a cue from that notification, Ministry of MNRE, Ministry of New and Renewable Energy, also came out with a notification saying that any projects being impacted because of supply chain disruption in China, and why the focus was purely on disruption in supply chain because of lockdown in China was because, one, lockdown happened in China first. Two, we were still so oblivion from the fact that COVID is going to hit the rest of the world as well, sooner than later. But as I said, some ministries were proactive, and in fact, MNRE also didn't stop there. It also went on and kept on providing extensions of time, for performance, till at least the lockdown was there, until the supply chain was disruptive in India. So that's all. I mean, we have been there, seen all, and that's, and it has become now such an, so it is both ways. I mean, eyesore for some, apple of eye for some, depending upon which side of the table you are sitting on at that point of time. However, the negotiation on force majeure has taken such a turn that these days, while you have a force majeure clause, and which is even, the most robust clause, a catch-all clause, which very clearly says what it has to say in terms of performance is suspended during the times. It even provides you a time period within which if suspension doesn't happen, the event is not resolved, you can even terminate the contract. In spite of all that, these days I have seen people asking a specific exclusion from performance as a force majeure event mentioned in the contract. I mean, they're so scared of the word force majeure that they don't want to take any chances, come what may. Then came some judgments. I'm sure Chanchal would throw more light on that. It's still a debate whether the Bombay High Court versus Delhi High Court, do they still have a contradictory judgment when it comes to encashment of LC or encashment of BG for that matter, Vedanta case. And I think we are going to have real fun as the jurisprudence evolves around force majeure, so to say. So with this, maybe, to start, I'll rather start with Navin. Navin, we would want to understand, what has been the relevance of force majeure clause per se generally in the contracts that you, as PSU and on the infra side, oil and gas side, face in the contracts, and what has really changed since COVID or during COVID and since COVID in terms of how you are viewing those clauses and any changes that you have brought in your contracts or your clauses from that perspective. It would be an interesting hear from you, Navin.
Yeah. So thanks, Pathik, and I think you set the context in a very beautiful manner. So, as you said about this force majeure clause and all, pre-COVID, people were not giving any emphasis on that particular clause, whether such clause existed in the agreement or not. They were thinking it is some kind of a legal language which in-house legal or lawyer will provide, and we are not concerned about that. Business team, they were thinking that they are not concerned about that particular language. So, like a EPC contract, just we said, so normally it is a capital, these type of contracts are capital incentive or long-term contract. So, general rule of the contract law is that contract need to be performed, that obligations given under the contract need to be performed. And if there is any, but in the long-term contract, there may be a situation where the party which are unforeseen by the party, that situation may happen, and which makes the performance of contract or obligations under the contract impossible. In that situation, what should be done? So our Contract Act, that we all aware about the section 56 and all, it provides for the termination of the contract in such a event. If suppose that contracts become impossible to perform, then it is a void contract. So it means that it will lead to automatic termination. But in case of a long-term and capital extensive contract, parties will not, this termination of contract is not interest of either of the parties. Like a principal or the contractor, even the principal also do not want to terminate the contract. Even the contractor do not also want to terminate the contract. So this force majeure clause is generally exceptions to the general rule. So basically when it is exception, that this Chanchal will throw more light on that. If it is exception, then it has to be interpreted in a very narrow manner. What the courts are saying that, so in that context, this force majeure clause becomes a very important clause in the long-term contract. It should be a well thought and well negotiated clause. So like I was just mentioning about this, pre-COVID, whatever our standard, like I am talking about a PSU like us, we have our standard force majeure clause or general conditions of contract, and contractors were coming and bidding on that particular basis. But today, after the post-COVID, even that in-house team, that business team, our engineering team, as well as the contractor side also, people started looking into that force majeure clause and then seeing that whether that force majeure clause, whatever was provided, suppose that 10 years back in that the standard contract, whether is it still relevant in today's context. So we have changed that our force majeure clause also to suit that current realities and current circumstances. And even this force majeure, now everyone just when you open that this dialogue, so you tell that everyone now started looking into the force majeure. We need to add this, we need to add this. So now this force majeure clause, it is, earlier people were saying as a boilerplate clause, now it is being looked as a tool to mitigate the risk. It is now a risk mitigating. People have, earlier also this thing was there, but now its importance has been understood by the people, and we are going in right direction. Hope I made myself clear, yeah.
Yeah, Navin, you sure have. Thank you for this. No, I agree with you, and that's exactly I said, COVID hit us, and we did not know what to do. And most of us were like home alone or homebound. So we thought, okay, let's have some fun, let's start sending notices to each other. And in fact, we did not even get to get to the relevance of force majeure to some extent. There were notices, please, no pun intended, I'm sorry if, it is not aimed at anyone if from an industry that I'm going to talk about are sitting here. But, service industries, say the contracts, which can easily be performed sitting at home, while the work from home was declared, even they started sending force majeure notices saying that it's force majeure, we can't perform. I mean, without really getting into the exact law behind force majeure, which is very clear about, it's not just an event, but an event which is reasonably beyond the level of performance by the parties, which has really restricted parties to perform in a manner they should have performed or would have performed under the contract. There is no way to mitigate, etc., etc. However, I mean, they said, "Wo baad mein dekhenge. We'll see that later. Let us send the notice." Because that's exactly, even the management didn't understand, the board didn't understand. They just said, "Send it." So, of course, I'm sure we all would have taken prudent decisions, like explaining the management what it means and what it should mean and how we should still behave in a particular manner. Because at the end, it was not just one company, one entity, or one region that was affected. The entire globe was affected. And I'm sure people ultimately had to put their head down, sit together and find a way, because, ultimately it was business for everyone. So with this, maybe before I actually go to Chanchal, I would rather finish the in-house part first, Chanchal, because, I am scared if I hand over the mic to an external counsel, we may not get it back, right? So with this, Amit, in your industry, what has been your experience? As I just spoke about the Bombay High Court versus Delhi High Court judgments, ultimately it all is also about, whether encashing an LC could have been stayed because of the force majeure conditions, or encashing a BG could have been stayed, or, was it a right or wrong decision? But what has been your experience, with force majeure in your kind of contracts, and what has what is the change that you have seen pre-COVID, post-COVID, and during COVID? Maybe should help.
Thanks. And the lighter side, I'll say that, from the financial sector, bank and finance, only these entities, financial sector, were not being hit by any COVID, because they were continuously on the service during the COVID period also. So not even a single day leave was there, not even a single day bank were closed. It was continuing their services. So basically, we have two categorizations. If you look at in the banking sectors, we have one documentations with our client and with the service provider. With the client, means the customers, whatever loan we are giving, it's not affecting anyway this force majeure clause, because we have right from very beginning. If you look at these all force majeure clauses, the operations of that, we used to cover it through third-party insurance. Like if you have taken the housing loan, you will believe that we used to ask you to give your fire, theft, this burglary kind of insurance. You have to take it. It's a statutory kind of things. Mandatorily you can't take housing loan without that. Similarly, if you have a stock, if you have taken the facilities against this stock hypothecated stock need to be covered from these all risk and all. To more further, one more steps that we are taking credit shield insurance also. That if you have happened to you, like if you have taken SBI loan and all, you will find that they are mandatorily asking you, first you have to protect your property as well as your health also. Even if you have one health insurance, but they will say, no, the credit shield insurance, you need to take it. So all natural calamities kind of things is being covered under the insurance. Banking, as far as the loan agreements are concerned, it's list affecting kind of things. If you are constructions related aspect, then we say, third party insurance, you have to take it, the constructions related insurance, you have to take it. So they are taking it out, and then we have another terms and condition into that. If you are not furnishing within a stipulated time, then we will of our own, we will take it and we will debit your account kind of thing. So these are the standard in a banking industry, from one bank to another bank, any bank if you will go, these all aspects are covered. Now recently, if you will look at, the RBI has said, if you have a locker also in the bank locker, you need to take your insurance for that. I don't know how the people will take the insurance. I am completely, but RBI has said that, you have to intimate your customer that, locker, whatever you have kept, you have to take your own insurance. Bank is not responsible for that. So if you are not aware of, please go through the terms and condition of the your locker agreement also. You have to take your insurance, because see, the locker, we are keeping out our assets not to disclose anybody, but when you are taking the insurance, you need to disclose to whole world that what are the things you have kept into your locker kind of things. See, the second portion which we are seeing it are the service provider agreements and all. So there the force majeure clause come into the operations, because if our operations are dependent, if we have an IT partner, if we have a service provider channels, if we have a outsourcing agencies for doing the certain activities, so for that we need to have this particular clauses. But during COVID, as because this where the services which was not being held up by any authority, so we were not facing anything, but still we had modified post-COVID that was there, that if anything you are facing it out, incapacity to do particular thing, impossible to do this particular work, then you need to communicate within 3 days or 2 days, so that we will evaluate, our committee will evaluate, we will examine, and then we will come to the final conclusion. So slight modifications has come up kind of things. Hope it's.
Yeah. Thanks, Amit. Would you want to touch now or later, Amit? Maybe in case you want to touch upon the BGLCs later, maybe next. Yeah, sure. That's fine. No, that's fine. You can. I hope we'll have time. Let's see. Yeah. So with this, maybe I would straight away bring in Chanchal from a litigator or external counsel perspective. And maybe it will be interesting to hear anecdotes from you on how have you seen this journey? I mean, how have your experience been with the FM clauses pre-COVID, or when COVID was not even heard of, so to say, and then suddenly so much of focus on the FM clauses, and we have seen so many disputes only on FM clauses, in the courts on various aspects and across industry. it has been sort of industry agnostic when it comes to disputes. So would be interesting to hear you on, on that journey, maybe.
My pleasure. Two things we need to understand in terms of the force majeure clause. One is that the force majeure clause is not new. See, the Contact Act was enacted way back in 1872. Even in Contact Act 1872, there were the provisions of Section 56, which talks about the frustration of contact. We all have been students of law and we all have gone through this provision. What is the frustration of contact and impossibility of the contact? So those were there. I am the one who was the general counsel and turned advocate as an external counsel. So I have been to both sides of the table. And even in 90s, when I was a general counsel for the corporate, we always used to have a clause of a force majeure. Yes, as for the scope of the force majeure clause, post-pandemic it has changed to the extent that lot many words, those were not included before pandemic, have started getting included in the force majeure. Something like, the pandemic, epidemic, lockdown, quarantine. Now when we make an agreement for our clients, we try to cover all these words in the agreement itself, in the force majeure, understanding that if the pandemic has come today, tomorrow is no guarantee that it won't come back again. In order to leave behind any kind of a speculation and interpretation, we try to cover this clause in the force majeure clause. Earlier, if we talk about the force majeure, it was more regarding act of God, So something like flood, something like earthquake. These were the words, those have been used in the force majeure clause. And that was the, the kind of the mindset or kind of the provision which we had in the Contact Act 1872. So that force majeure was there since 1872, is not something new that has come out only after the pandemic. Before pandemic, before lockdown, before COVID, the force majeure were there. All the advocates normally used to advise all the clients to have that clause. But yes, the provision of the force majeure, that has changed, that has enlarged, that has been widened, in order to protect the right and the interests of the client for whom we are preparing the agreement. Now we also need to understand what is the force majeure. Force majeure, understand that neither party will be liable for any failure or delay in performing an obligation under this agreement, that is any of the following causes: that beyond the reasonable control, that is act of God, as I was talking, that was the one which was well before there, even this pandemic. So act of God, accident, riots, war, terrorist act. Now I'm using certain new words that has been added only after the pandemic that we have seen in sometime in 2000 and again in 2021. That is epidemic, pandemic, quarantine, breakdown of communication, breakdown of web hosts, breakdown of internet services providers, government act or omission, changes in law and regulations, strikes, fire, generalized lockdown, unavailability of the raw material or energy. See, these are the words that has been added post-pandemic, and it was needed because lot many contact that has come before the court to understand whether this part of the contact comes under the force majeure or not. One of the experience that I want to share with all the audience, I happen to close an agreement for one of my clients who are into the catering and decorations. They were doing the catering decoration. Mumbai, as you understand, a lot of banquet halls are there for a lot of events that is to be organized, and a high value contact. So I drafted a contract. As usual, before pandemic, the situation was hardly 2 lines to be added as a force majeure. So we put all this force majeure clause in the agreement. But because of the pandemic, he was unable to perform any kind of the event in the banquet hall. And it was continued almost a year. Reason is being that though the pandemic was lifted, or the restrictions were lifted, but yet certain type of restrictions were continued for almost a year. Like you can't invite more than 50 from the groom side or from the bride side. Now a caterer who is paying a high value rent for the premises, who has given 10-20 crores of deposit for that kind of premises, if he is restricted to invite the 50 guests or the 100 guests, imagine his situation, that how he would be able to meet even the expenses that he is otherwise required to maintain such kind of the premises. The property was owned by a trust. I'm just sharing a live example that I have gone through in respect of the force majeure. So our client has spoken to the trustees of that trust and said, sir, this is the reason, and therefore we have not paid for the 1 year or the 6 month time that he has not paid. And that needed to be excluded because it was a kind of the force majeure situation, because we were unable to perform any kind of the function. And since we have not collected any revenue, any money from the parties, from where will we pay you the rent? As usual, the trustees were not agreeing to that and was insisting that whether you were able to perform or not, because the rent was decided on a monthly basis, not on the function basis. So whether you were able to conduct the function or not, whether you were able to invite 50 guests or 500 guests, we have nothing to do it. There is a fixed rent and that you are required to pay every month. And if you have not paid, the contract is subject to termination from the trust side. A lot of negotiations has happened. In fact, our client was also insisting the contract period needed to be enhanced, the 6 month period, that he couldn't made use of the particular hall, the banquet hall. So the contract period, if it is ending in the June, and the 6 month period he has not used, so it should end in the December. So 6 months should be extended, because that is the period of the time that he has not used. The trustees were not ready to do that. Finally, we had no other option but to move to the civil court there in Mumbai, like Dindosi court that we have over there as a district court. And the matter was argued heavily before the court. And finally, the honorable judges have passed an order in favor of our client and have allowed him to continue for the 6 month. Deposit remained in the custody of the trustees. The rent, of course, he was required to pay for the 6 month period that was extended. But then, it's all left on the interpretation of the pandemic clause or the force majeure clause, because those words were not added at that point of time, because nobody has envisaged the situation that a time will come when we'll be restricted to move out from our own house. So those restrictions have come. The lot of, because of the lockdown, lot of restrictions have come from the police, from the local authorities, and the business were almost come as at halt, and the people were unable to earn anything. So those were the situations that needed to be dealt with. So post-pandemic, what is required now, that we need to be more clear and try to cover all the words that we have already faced into, and maybe add something that is yet to come, and we never know as and when we require to face it. So as an advocate, as a lawyer, we need to be little futuristic, kind of the situation that the client may face in a given time, and we need to cover up in the force majeure clauses, by virtue of which, even if situation arises like it has happened in 2020 or 21, or maybe worse than that, the interests of the client remain protected, and the client is not required to pay for the period for which he has not been using the premises, or the contract has become frustrated because of the enforceability. Now, these two provisions, if I remember, Section 32 of the Contract Act and Section 56 of the Contract Act 1872, these are the two provisions of the Contract Act is very necessary. So while drafting any kind of the contract, whether it is a technology contract or the rest of the other contract, we need to be, even for the matter of the home loan or the project finance loan, or for the rest of the project loan kind of the things that the bankers does, we need to be little careful about it, and we need to cover it up, so much so that if a time comes, we are able to protect our own rights because of the impossibility of the contract, and because of the frustration of the contract.
Sure, thanks, Chanchal. I mean, this has been, of course, quite food for thought for us in-house counsels, on how an external counsel would have looked at it or looks at it. And I agree, as while of course, Section 56 has been in operation since long, and Act of God, so to say, has been. But then again, there also has been a debate about whether pandemic would automatically fall, under the Act of God or not. Supreme Court of India, while has not really, in many judgments, have not really come out saying whether pandemic is an act of God, it's not an act of God. However, the inference from those judgments, of course, has been that more often than not, pandemic.
Something like the Alopi Prasad and Sons Limited versus Union of India. These are the 2-3 judgment is a landmark judgment in respect of dealing with the force majeure clauses. Something that I can quote before you guys is Energy Watchdog versus CERC, Satyabrata Ghosh versus Munir Rahman Bangur and Company, and Alopi Prasad Sons Limited versus Union of India. These are the cases where the Supreme Court has dealt the matter in detail and have narrated as how the force majeure clause should be read and should be enforced in order to protect the interests of both the parties of the agreement.
No, I agree, and that's what I meant. Of course, they've gone in detail, dealt with the matters, but today, correct me if I'm wrong, but in my view, today also there's no real rule of law which says that any pandemic would automatically get into the Act of God, whereas the Supreme Courts of US and UK have actually long back gone ahead and said, in various judgments, including in flus, which have been epidemics or pandemics, where they have really categorically stated that pandemics should be treated as act of God in judgments. So exactly. So I think we also need to be jurisprudence also still need to evolve. I don't know for how long will we remain a developing nation, but that's how it. But having said that, any anecdotes, anything that you would want to say, Navin? Sorry, we have kept you silent for a long time.
So basically, that whenever the force majeure situations occur, so I saw that two kind of situation. One, suppose a party try to take advantage of that particular situation. Suppose you do not want to perform that contract, but under the garb of that force majeure situation, he'll say, no, now force majeure situation has occurred, and that's I'm not able to perform, and it should be suspended. And the second category will be where the genuine impossibility to perform the contract is there. So while looking into whether it is falling under the force majeure situation or not, we need to see whether it is difficult for a party to perform the contract or it is impossible for the party to perform the contract. If it is difficult, then it is not falling under. So like I just quote an example, that real example. We had a refinery in our Kochi, that is in Kerala, and that EPC contract was given to a contractor for a period of that contract need to be performed this thing within a period of 12 months. And the contractor, there was some delay on the part of the contractor, but during that monsoon period, because the force majeure clause said that flood, so he issued a notice saying that no, this is a heavy rain is there, and due to the heavy rain now it is a force majeure situation, and I'm not able to perform that contract, and here there's a force majeure notice. So there we responded to that, because that this in Kerala, that in monsoon period, at the time of entering in that particular agreement, everyone is aware that in Kerala or in Mumbai itself, at the time of monsoon, heavy rain will be there. So while quoting for that particular tender, all these things, parties are aware what need to be taken in that. So heavy rain cannot be termed as a force majeure situation. So those kind of things are there. Like Amit was also telling in the technological front. So suppose during the quarantine period and all, if you are able to perform that your work at that sitting at home, you cannot say that it is a force majeure situation. But that force majeure situation maybe for some other kind of contractors. Like our company also, because it is essential commodities, we need to maintain our supply chain. All retail outlets, LPG distributorship, everything has to be open. So my contractor cannot say, no, look, it is a force majeure situation, I will not come and work. Whereas the company need to perform those things. So we need to see at a case-to-case basis. Fundamental thing is whether it is that particular event is making the contract difficult or impossible to perform.
No, I agree, Navin, and I completely agree. There is no one-size-fits-all approach that you can really apply here. It will depend upon facts of the matter. It will always vary case to case, and of course, force majeure. The fundamental of force majeure is it's not just an event, but it has to really push you back on performance. I mean, there is no reasonable way for a party to perform, and there is no other way to mitigate that non-performance, is when force majeure generally should kick in. And I also agree with you, the same example, oil and gas or energy sector. I mean, one was COVID, other one was lockdown. And, the consideration also had to be given whether the force majeure per se is COVID as a situation or the lockdown that is emanated from or because of this. Because, even with the energy sector, you had to maintain, it was an essential service, right? So you have to really keep operating that. But now, how do you operate it if you don't have a means by way of any public transport for your employees to even reach remote sites where maybe, your solar parks or your wind parks are installed or are operating? So it was definite, I would not maybe use the word like a lack of thought, but definite lack of real understanding as a concept on what should be force majeure, what should not be force majeure, and how one needs to read a clause.
So Pathik, I just want to add here, because this mitigation, the discussion among the party to mitigate that effect is very much important when these force majeure situations happen. Like the example what you said, like suppose a lockdown is there and that worker cannot reach to your this particular plant and all, then in that particular situation you cannot blame that contractor or that this thing. So for that purpose, because then like in our industry, there were that concession was given by the government of India that these plants can open, this vehicle can move and all. So those kind of this thing is provided. Suppose had those kind of provisions and concession was not there, obviously the other party will say, I am unable to do this. So that mitigation measure, communication between the parties, to see the interest of both the parties. You cannot look at your own interest. You need to see that interest of other parties also. And where the dialogue and everything is clear, this resolution will be, you can arrive at that particular resolution. When both parties are looking at their interest only, then matter will go to the court and honorable judges will decide what to be done.
Sure, I appreciate Navin. Amit, you have been trying to say something.
Agree with the Navin ji's view. See, the essential services were allowed and concessions were given to move and all, including the banking also. Though we agree with the Supreme Court has not very clear on this particular aspect, but the benefit of doubts were given to the customers as well as the vendors and all. Because if you look at from the banking perspective, Supreme Court keep on extending this particular NPA. The bank cannot declare NPA because that all period has just excluded. Even no actions can be taken during the COVID period and all. So that also was continuing for a longer time. Though they were not clear, but still RBI was keep on asking, regularize the account. So in between, the intermediary kind of circular we used to being given to the banking and financial sectors, to cater kind of things. They were not been given the repayment kind of things. There were some.
As invariably said, it is a human face. It is not purely precisely the law requirement, but there were some sort of the human face, even the judges or the courts also has, because they have understood the kind of the situation that everybody was facing through. The salary were cut, the people who are not getting the salary, and those salaried people defaulted in making the payment of the EMIs, those periods have been excluded and they have been given the relief.
Keep on extending kind of things till, the last limitations, you have during that period, limitations is not being barred kind of things. You can have from that date and onwards, limitations will continue. Account can't be declared as an NPA. So a lot of...
Court, while analyzing these facts, the court has said the hardship is not the remedy or for the reason for the invocation of the impossibility. Are you getting me?
True.
You might be facing the hardship, but what you need to prove before this court is the impossibility. That it was impossible to perform. Absolutely. Merely saying we had the difficulty, we had the hardship, we had the loss, we had the profit, we had the less revenue, we had the more revenue. I mean, those cannot be the reason for implementing or for the, as for the invoking the force majeure clauses.
And
the force majeure clauses is for the impossibility. True. Was that the situation in which it was made impossible for you to perform? If the answer is yes, of course the force majeure come into play. If the answer is no, it was merely a hardship or difficulty, no force majeure could be implemented in such situation, because then it becomes very difficult for the parties to perform or to fulfill the obligation that is written under the agreement itself.
Yeah, but still, of course, some standard provisions were, or standard benefits, like moratoriums was one.
Restructuring of the accounts.
Restructuring of accounts. So this was one. Yeah. So
specifically on the bank guarantee, what has happened? They have not given, because they said that bank guarantee is a separate contract and how it is affecting kind of thing. So they have not given the relief just because of the bank guarantee is a separate contract. They have Supreme Court was of the view.
The law is also evolving to that.
Absolutely.
You need to understand the law is not framed. Court has also the first time faced such situation.
True.
Where in such situation the parties were coming before them. So law is not clear. There is no past order of the judgment to that
precedent
so
to that.
it was, kind of the evolvement of the law in a situation in which how the court should.
No, completely agree. I mean, while businesses may definitely would have suffered, lawyers definitely gained a lot on terms of knowledge from from an episode like this. So maybe quickly. Sorry, Chanchal, you want to say anything more? Or no? I was just opening this before we make our concluding statements. Maybe any questions? Yes, sir.
It's not a question. It's not a question, see what happens is, if you look at it, Supreme Court invoked Article 142 and extended certain time limit from the, what do you call, time barring.
Time clause, yeah.
Time barring. And also introduced another section called 10 capital A in the IBC, saying that during that time, if you have declared an account as an NPA, if you go and file a section 7 or 9 or, application, that is not valid, So, and subsequently what happens is, the Supreme Court or, none of the courts or, never said that, it's only a deferring of the payment. It is only a deferring of your contractual obligations. It never said you can write it off.
They've never been exempted from
Write it off is not written at all. So, as somebody said there, is that in 2018 in Kerala, there was a heavy rain and landfall and everything. But that is a state subject and, see whatever happens, for a pandemic, it has to be declared as a pandemic, which has to say that, you are unable to perform certain things. And in Bombay and all, what we did was that, we renegotiated many contracts. Renegotiated and, made the rentals payable to half or, 25% and something like that. So, ultimately, the short question is that, even if I write in a contract that it is a pandemic will come as a force majeure. It is not that I can say that, there was a COVID and, now in 2024, if we write pandemic and if a COVID resurfaces, I don't think we will have the same effect as it was in 2020 because, nobody now bothers about COVID, because it's all over. And, that is the reason. So what is done was only a deferring of the payment. It never gave any blanket exemption to say that you don't have to perform your contract, That's
that is true, but this is exactly what force majeure anyway is all about, right? Suspend the services where services are capable of being suspended but can be taken over. However, if like section 56, if something has happened which has just frustrated the contract.
Either you can terminate the contract or, you can, you give some 6 months
and that is when
time
normally you keep a suspension and termination, both rights in a contract under force majeure.
So pandemic as such Even if we write, is subject to what the court says. You know, the court has to say whether it's something which was incapable, which prevented me from fulfilling my contract, and as a result, you know. See,
no,
yes.
Precisely, if we talk about the section 56, the frustration, it make the agreement itself as a void. Are you getting me? If that clause come into effect, section 56, if you talk about the impossibility of the contract, the frustration of the contract itself become void. Neither party can be held accountable, responsible for the non-performance of their obligation under that contract. So 56 talks about the not voidable, the complete void of the agreement, because you have entered into something which cannot be performed by the other party, you know, by one of the party or by both the parties. In such situation, agreement itself becomes the void and unenforceable. It can't be enforced.
That is again, you know, for the pandemic, it has to be decided by the court. You know, essential services were there. You know, the manufacturing activity was not stopped. We were getting food. You know, we were getting all kinds of Maggi and everything. You know, biscuits and everything was manufactured. Medicines were there, and you know, ultimately, second thing is banking service was in full swing, and you know, therefore, I think it's left to the court to decide. But we can still write that. You know. I don't want to.
So, as you can see, intentionally we have not left any time for Q&A, but in case there is any still one question, we can still take, time permitting. Okay, so I'm glad. So thank you so much. I think it was, you know, the topic is such that we definitely can go on and on. It's so fresh in our minds right now. And maybe some of us, sorry, but maybe some external counsel are still waiting for some other pandemic to happen, because I... Exactly. We even went to the extent of debating, you know, whether lease, you know, I mean, we had a whole long debate of lease versus license, and whether it is a force majeure, whether, you know, we should stop paying rent or a license fee in force majeure or not, and how lease is different from license, and so on and so forth. But with this, I think, thank you so much. You know, thankfully, I didn't see many sleeping faces while we were right after lunch. So I assume, and as lawyers definitely do pat their back, I assume we did a good job. Thank you so much. And thank you so much for being a lovely audience. Thank you.
Hearing after post-lunch.
Thank you, gentlemen, for putting up such an interesting and a great session. A huge round of applause for all our panelists.